concerned means that it's prior art, right? When there is prior art, nobody can call it an invention. It's not new. But when we talk about public domain under the copyright law, what it means is that the author no more has the rights. If I write my book, it gets into public access, but it doesn't go into public domain. Do you understand the difference? Public access means all of you have a right to access my book, but you cannot make copies of that book and give it to anyone. So the work will get into public domain only when I die, and after 60 years it gets into public domain and anyone can make use of it without taking the consent of my legal heirs. Right? So these two words, that is what, what normally happens is people don't make a distinction between patents and the copyright law. Patents work on novelty, copyright law works on originality. And when you're talking about originality, we are talking about the more of form and expression of work. More important is the language and the expression that you give to it than the idea behind the whole thing. Idea is protected under patents, expression is protected under copyright law.
Thank you.
Right. Anyone else?
I would just add on the Creative Commons coming from Silicon Valley is that Lawrence Lessig was part of that. It was part of this copyleft movement, and the
Yes.
idea there was Creative Commons itself is a nonprofit. At least there is a nonprofit called Creative Commons, and the concept there is anytime you create something, it's all rights reserved. You've reserved all rights in that. Remember earlier from Balaji, he was talking about airborne rights and movie rights, theater rights, performance rights. So the idea behind this nonprofit was, forget all rights reserved. Let's have some rights reserved. And let some rights be in the public, right, in the common, so that you don't always have to seek permission. So if it's just attribution that they're seeking, that, hey, just attribute that I had created this, but feel free to use it anywhere you want, just give me attribution, then they have certain licenses on their website, certain formats that they're trying to push, that every content provider shouldn't reserve all rights. He should, at the very inception of those rights, say, look, some rights are reserved. Here are the rights that are out there in the public. Feel free to use them. And the concept, I think, historically was, look, originally content took a lot of time to develop, and Disney wanted all contents, everything. But today's content user, with the ubiquity of the internet, is creating stuff that he doesn't mind being shared. He wants his ideas to be disseminated, social networked, etc. He just wants certain rights. And so they have, I think, 4 formats in Creative Commons where it's like, here's the different things that the content wants to keep for themselves, and here's a format of how to share them. So I think that's one of the things to clarify further.
See, what has happened as regards copyright and copyleft is concerned is what the 2012 amendment last year has done. It has talked about what you can assign and what you cannot assign as far as the entertainment industry is concerned. Okay? One of the solutions, that's my last slide, I gave was that the owner should be clear about his various licensing rights. What happens is the owner needs to know various rights that he has. The problem in India is that even the copyright owners do not know what their rights are. So when they enter into a contract with another party, what they do is they say that we assign all our rights. For example, when I write a book for a publisher, I tell the publisher I assign all my rights, right? Now, if from the print I'm writing something, literary media, it goes to the literary media only, there is no problem, still the story continues to be the same. But what has happened in case of cinematograph films is that there is a new provision which has been added for assignment of copyright. This is, you must have heard of Javed Akhtar and the others following this movement. And one of the limitations which is given is that the lyricist or the composer of the music and the scriptwriter of the film, when they enter into an agreement with the cinematograph film producer, what they say is we assign our rights for the purposes of making a film. That means if that their work is to be used for anything other than theatrical use, what will happen is that the producer of the film will have to share royalty with the authors. That means with the scriptwriter, with the lyricist, and with the composer of the music, whichever way it goes. So what you have done is that you've specified. Now, there's a whole debate on jurisprudence of rights here. The whole debate being means that if you have a proprietary right on something, then you should be the one who should decide for yourself what you can do with your property. So the entire negotiation goes away in this case because the person assigning his rights to the producer cannot assign certain rights, they have to remain with him. Now, why this happened was basically to give power to the authors as far as, vis-a-vis the producers of the film. Because we all know that producers of the film are the giants in the field, and the authors and the people who give the music, etc., are very small. So what you need to do is that giants know how to protect their rights, so you needed to protect the rights of the lower category people also, and that is what there have been amendments in section 18 and 19 of the act which deals with assignment and mode of assignment. And they've said that if there is an agreement which talks about assigning of your rights, that means the scriptwriter, music person, then what will happen is that agreement would be a void agreement, meaning that this has become a kind of a public policy in India. So what we talk about the Contract Act, where it says that if a contract is against public policy, it is a void contract. So by by an indirect means, we have added a public policy to the Contract Act, saying that this is what public policy is given in the Copyright Act.
Ma'am, if, if I may, given the interest of time, let me try to bring in Dinesh here at this juncture, because, I was given a question yesterday, only yesterday, from someone who's been approached to write a book. And he's so famous for his content that he has always been writing editorials for different newspapers. And he says, if I just took all my editorials that I wrote, I could have a book. And I said, watch out. If you got compensated for those editorials, you don't own them anymore. He says, they're my work.
They don't compensate.
So
They don't
tell me, Dinesh, how does that work?
So that's absolutely the way it works. I mean, if I have a full-time employee and my contract with that employee says that all the work that you create as part of my employment will belong to the organization, and therefore, even if he has to use in his own book, he has to seek my permission. So that's the way it works. But I mean, the good thing in media is I don't think that, at least I can talk about the print media, that we have ever been trying to restrict the dissemination of that article or good thought. So, I mean, we've been very liberal with each other in terms of, allowing to publication of that in various mediums, being used even in converting into different mediums. So,
But what if this is not a full-time employee, but a famous person in a field, but whenever something happens in that field,
the moment he get paid, the part of the contract will clearly say that you're being paid and therefore the copyright in this article will belong to the organization.
do you have a different opinion, ma'am?
Yes, my husband has written umpteen articles in various newspapers, but not in Hindustan Times. And one, there is never an agreement between the newspaper and the writer. Secondly, there's never a payment given by the newspaper to the writer.
So in that
So therefore,
case,
what happens is the writer becomes, now you have, if you look at the newspaper, you've got different kinds of writers. One is those who are in whole-time employment of the newspaper, and secondly, those who are, they're just writing for money, and the third is those who are just contributing articles. So we've got different kinds of authors. Those who are in whole-time employment, they assign only their publishing right to the newspaper. See, for example, if I am in employment of Hindustan Times and I write a story in Hindustan Times, now what happens is I make a film out of it. Then Hindustan Times can't do a thing about it. Because what is with them is, yes, that's what Section 17 says. They only have the publishing right, not the right to make a film.
So that's what I was talking about, Alka. I think we have to go back and see the contract, and there are contracts.
No, that's what I'm saying. There are no contracts by the newspapers.
No, if it is an honorary writer, for sure there are no contracts. But if somebody is writing for payment, like I have 2,000 journalists across country,
Yes.
all the rights. I mean, all the rights, not only.
That's commissioned work that you're basically talking
period.
about.
It's a commission work.
Yes.
So,
So when it is a commissioned work, and as I again repeat, they are the larger fish. Right? They are the bigger fish. And the Matsya Nyaya says, the bigger fish eats the smaller fish. I am a writer, I've written 2 books, and I can't negotiate with a publisher. So publisher comes with a standard form contract, you have to put a signature on it. So when you put a signature on it, what do? I assign all my rights to the publisher.
Yeah.
So when I assign all my rights, they can well do anything with it. So that's how, so therefore, since the legislation, and since the authors in the print media could not form a lobby, as strong a lobby as Javed Akhtar, and the others, therefore, there were changes made for the cinematograph film authors, but there are no changes for the authors of the print media. But even here, after having the legislation coming into existence, what is happening is that the producers of the film, they have challenged this provision in the court. So therefore, what they are saying is that our right and freedom to carry on with the movies and freedom of trade, that is what you have under Article 19(1)(g). Under that, they are challenging it, saying that it is an unconstitutional provision. So tomorrow, what is going to happen? We still do not know. Whether the big fish remains to be the big fish, or the legislation does something for the... anybody wants to say something? Yes.
Now, if you see section 17 of the Copyright Act, it clearly says that unless there is a contract to the contrary,
There's a mic.
so unless there is a contract to the contrary, so therefore, if there is a contract between the two parties and all the rights have been assigned,
Okay.
so
Yes.
therefore the existence of the contract to the contrary has to be proved.
That's what I said. So what is happening is, so what these people do is, I'm sorry, I'm not pinpointing at him, but what I'm saying is the publishers. So what they do is they bring a standard form contract, and once you assign your rights, contract law comes over and above the copyright law. So copyright law becomes a lower kind of a category. So therefore, one has to be very, very careful in signing the contracts. But then you can't be careful because you are the smaller fish, and since you're the smaller fish, you have no options available with you. Either you want your work to go into the market, or you stay with your work. So it's better to enter into that contract and get that little bit, whatever they give as royalty, for some years to come. Yes, ma'am.
Ma'am, my question is that there's a recent controversy going on over the show Comedy Nights with Couple, in which a certain character, Gutti, isn't really the person who plays that character, has actually left the show, and there's a controversy over the fact that who owns that character, the artist who has created it, or the channel, the producers. So what will happen in that case? Are you aware about that case?
Well, I'm not aware, but what I'm trying to, but I can give an answer to that.
But Dinesh has a thought on
Yes.
that.
all
So
right.
I mean, my thought here is that the Gutti per se, the title or the name, I guess belongs to color, because that's how they developed it. But the expression of that Gutti by that actor called Sunil, that belongs to that gentleman. I don't think anybody can take that presentation, the style, the way he speaks, where he has to stop. That creativity belongs to Sunil, and I don't think that can go away to colors on anybody for that matter. So it's a little hybrid. Some belongs to colors and some belongs to Sunil.
And the implementation is going to be really difficult.
Yeah.
Can I
Yeah.
just add here? There was a case on, this was regarding Devanand. The way Devanand puts his head up. And the same way Rajesh Khanna started doing it. So he challenged, and the court had said that there is no copyright in style. R.J. Anand's case came way back in 1970, and that still remains to be the Bible of copyright law in India. And there is no copyright on style, there is no copyright on makeup, there is no copyright on various gestures that you make. So this is what the law till the time is. So therefore, neither the colors, nor, I've not seen the show, that is why I kept quiet, nor the Guthi, whatever you're talking about.
I've not seen the show.
So-
I've just read it in the newspaper.
So the controversy, basically, it doesn't belong to anyone. I can sit like this, and he can't say anything to me, right?
So the thought here, though, is depending on how much guidance was given to that guy, Sunil, by Kapil, the owner, saying this is the kinds of characteristics I would like this person to have, I think those all belong to colors. At the end, if this person has brought something unique in terms of style, I don't think they can keep those, but they'd have to delineate them. That's why this is actually a mess.
Impossible.
It's a mess, and it'll be interesting to see whose side the public sways on.
No, I personally feel there should not be copyright on the styles and the way you speak, whether there's something novel about it or not. Because as far as your facial contours and your walk and your gait and everything is concerned, that's all copyright vests with the god. But what we do, there cannot be a copyright on that, because then what we will do is we will put a full stop to creativity. So therefore, I personally feel it neither belongs to colors nor to the person concerned, and anyone can copy you.
I think you have an editorial right here ready for your paper if you're interested. Ladies and gentlemen, we're done. I think, ma'am, thank you so much for
Thank
coming and taking over the moderation. And Dinesh, it was nice to hear from the HT from the point of view. You're not the big bad fish all the time, but we really enjoyed it, and we're going to be around here if you have any questions. Thank you.
Thank you.